Technicians, February 5, 2026 board meeting. This meeting is taking place at the Department of Consumer Affairs, first floor hearing room located at 1625 North Market Boulevard in Sacramento, California. My name is Dr. Carol Mountain, and I am the board president. I would like to call this meeting to order at 10:01 a.m. First, some housekeeping information on how this meeting will be conducted. This meeting is being held in person. Yes. One of our board members is remote. Our board member who is remote is Nellie Neeblis.
And she just logged in.
Perfect. Excellent. If we need a motion, I will call for a motion, a second, and open for public comment prior to taking a roll call vote for each motion. Members, for the record, please state your name prior to making your motion or when seconding a motion. Please turn your microphone on when making or seconding motion to ensure accurate record of the motions. We will take public comment on each agenda item. Each member of the public who requests to speak will have up to 3 minutes to speak, and you will be notified when you have 30 seconds remaining. You do not need to provide your name, but please indicate how you would like us to identify you if you are participating via WebEx. For the sake of efficiency, the executive officer may respond directly to public comment or defer to the appropriate staff person or counsel as appropriate. For any questions directed to board members, I will either answer the question or direct it to the board member as appropriate. However, the board will not engage in discussion or take action on any item not on the agenda. We will now do an alphabetical roll call to establish quorum. Board members, when your name is called, please introduce yourself and give a brief description of your role with the board. Alita Carpenter.
Good morning. I'm here. I'm a gubernatorial appointee and a public member.
Gloria Gregorio Guzman.
Sorry about that. My name is Gloria Guzman. I'm a governor appointed LVN.
Thank you. Leslie Moore.
Good morning, Leslie Moore, Governor Appointee, PT.
Thank you. Nellie Neeblis.
Nellie Neeblis, board member, governor appointee,
Thank you.
and public member.
Dr. Johnny Russell.
Dr. John Russell, board member, LVN, governor appointed.
Rashima Sansan.
Good morning, Rashima Sanson, public member, governor appointed.
And I'm Carol Mountain. Based on the roll call, we have a quorum. We can now move to agenda item 2, introduction of board, staff, and council. Ms. Yamaguchi.
Good morning, everybody. Thank you so much for coming to our meeting. Celine Yamaguchi, the BVNPT's executive officer. We have a very small group of the staff here today. Our AEO, Mark Ito, our admin team, Jeff Weiler, Nikki Brady, and Renee Frenson, counsel, and our special guest counsel.
Ileana Butu, the board's legal counsel.
Christy Shields, Regulations Counsel.
All right. Thank you so much. We will now move to agenda item 3, morning session, rulemaking process overview. Ms. Shields.
Good morning, everyone. If we could go to the next slide, please. So by way of introduction, my name is Christy Shields again, Board Regulations Counsel. My background is that after working in the private sector for 4 years, I joined the Department of Consumer Affairs, Legal Affairs Division in March 2000, where I've worked in various capacities, including as general board counsel and litigation counsel for many of the agencies in the department. I'm currently assigned to the Regulations Union as Regulations Counsel for this board and 7 other boards and bureaus. I also provide training, act as coverage counsel, and act as a second-level reviewer for other agency rulemakings as directed by management. Today, we'll be discussing the process of adopting regulations through a regular rulemaking, the most common form of rulemaking under the California Administrative Procedure Act, and your role as board members in that process. My goals are for you to get an introduction to the rulemaking process and preview some of the standards the board is required to meet under the California Administrative Procedure Act, the law which governs how regulations are adopted by state agencies. And I have with me today a copy of the California Administrative Procedure Act right here. These are all the rules and regulations and statutes that you have to comply with to get a rulemaking adopted. So just be aware of that. I'm going to try to synthesize the salient points, the most important points of the APA for you. Next slide, please. Since regulations have the force of law, state agencies must follow the process outlined in the APA to ensure due process to those affected by the regulations proposed to be adopted, amended, or repealed by a state agency. This board's regulations are contained in Division 25 of Title 16 of the California Code of Regulations. Next slide, please. We begin our discussion with what a regulation covers as defined by the APA. A regulation is defined in the Administrative Procedure Act as every rule, regulation, order, or standard of general application, or the amendment, supplement, or revision of any rule, regulation, order, or standard adopted by any state agency to implement, interpret, or make specific the law enforced or administered by it, or to govern its procedure. And that section of the law is Government Code Section 11342.600. The California Supreme Court, I want to draw your attention to the term standard of general application in that law. The California Supreme Court has defined the standard of general application to mean that there is broad reach. Whatever rule, order, or standard the board is implementing applies generally to all members of a specific class rather than to a single named person or a specific enforcement case. It provides future guidance. It is a written policy that predicts how an agency will decide future cases and is unrelated to a specific individual enforcement case or action. Effective law. If a rule looks like, reads like, and acts like a regulation by imposing a standard that everyone in a certain group must follow, it is treated as one, regardless of what the agency calls it, a guideline, a bulletin, a manual. That is the California Supreme Court's interpretation of a standard of general application. So keep that in mind when you're deciding whether you need to adopt regulations. Next slide, please. Why are regulations necessary? Regulations are required by the APA to be adopted whenever the statute is not self-executing, meaning the words in the law are susceptible to more than one interpretation, or the legislature specifically requires you to do regulations to implement a law. So it says it in the law, you have to do a reg. You have to do one. Or it's not exempt from rulemaking. Sometimes laws will say this requirement is exempt from the California Administrative Procedure Act. That is rare, and the legislature usually disfavors including that in there because they prefer that the agencies engage in rulemaking before they adopt a standard generally. And then a regulation is needed if you need to implement, interpret, or makes the law more specific that in your practice act. Next slide, please. So here's an example, a simple one, I think, to show you when a regulation might be required. So if the law says the application fee shall be no more than $500 and may be increased to not more than $600, any reasonable person looking at that would not know what the fee is. It could be $500, it could be $600, it could be something in between. So if you ever look at a law and you don't know exactly what it means right away, that's a clue that you might need a regulation to interpret that statute so everybody enforces the law in the same manner. Next slide, please. To begin our discussion, I'm providing a general overview of the standard regular rulemaking process. This is a flow chart which highlights the areas that include direct board member involvement. We're not going to spend a lot of time on this chart because we're going to go into more detail about it, but you can see in the highlighted areas where the board, you as board members would be participating in the rulemaking process. Next slide, please. So in this department, we have come up with 4 categories of stages when your rulemakings are, like where you are in the process. This is not in law, this is a departmental policy. And the 4 stages we generally refer to when we're reporting to you at board meetings where things are concept, production, initial, and final. So the concept is where the problem is defined and proposed text is developed by the board. Production is where you've approved the text and the staff begin preparing the supporting documentation required by law to be prepared to defend the policy decision you're making before filing with the Office of Administrative Law. Initial is where after the rulemaking is filed, the proposed text and rulemaking documents are published and a 45-day public comment period begins, and possibly 1 or more hearings is held to receive public comment on your proposed rule. Final, where the board responds to comments received during the comment period, decides whether to modify text, and then acts at a board meeting to approve the final text. Once the text is approved, staff finalizes supporting documentation and submits the final rulemaking file to the Office of Administrative Law for review. Next slide. Concept phase. I would say this is the most difficult part of any rulemaking, is deciding your policy and finalizing your text before submitting it to your control agencies, I call them. Those are the agencies that are going to review it, potentially attack it, require you to defend your position. Getting it into a solid proposal is the hardest part. That's the heavy lifting from a regulatory perspective. Generally, we've found that the board should address all objectives prior to filing a proposed regulation to help ensure a successful outcome. The more work you put in at this stage, the easier the process of adopting a regulation becomes. So what we're talking about here are defining the problem, describing the objectives you hope to achieve, brainstorming possible solutions, consulting with those who would be affected. You're required by law to consult in advance before you begin the rulemaking process when the proposal is complicated, complex, or large, meaning there are a large number of proposals that can't be reasonably understood by the regulated community within the 45-day comment period. So if you have hundreds of regulations you're proposing at the same time, you're required by law to engage in stakeholder outreach and confer with the public and participate with them in stakeholder meetings prior to filing. We also recommend doing this when there's maybe a contentious or controversial issue, because if you do this in advance of filing, you can often come to consensus with those affected by the regulations so that you have fewer adverse comments when you're actually after you've filed it. Then, you list and evaluate the costs and benefits. Hopefully in your meeting materials, we would cover this. We choose an option or solution and be prepared to explain why it's the preferred one after we've done all of that groundwork I just mentioned. Next slide, please. So as far as concept development for the board members, then the process here is outlined in this flow chart here. The idea for a regulation can come from a statute, from you in your experience, from board staff, from regulated public, industry groups, people you interact with, based on your experience and knowledge. The process starts when the board's president, in consultation with the board's executive officer, places a concept on your agenda for discussion and possible action. Typically, the board staff will work with Regulations Council to develop concepts for regulatory proposals and bring these items to a board meeting and present them to the board for discussion. However, if the proposal involves, like I said, complicated or technical subject matter, the board may use a variety of methods to develop the language. This includes in development activities being sent to a board committee like we have for the Education and Practice Committee for the scope of practice updates we're going to be working on for the licensed vocational nurse, directing staff to engage with stakeholders at meetings, or contracting with subject matter experts to help explore and develop concepts when it's very technical. Next slide, please. Once the final draft is ready, the proposed text is generally provided in a document called Proposed Regulatory Language to the board members, and the text is shown in underline for additions and strikeout for deletions, so it is clear what changes the board would be making. You can see examples of the board's regulations page of the different regulatory packages that we've worked on over the last several years. That document, that proposed regulatory language, is provided along with a cover memo to the board explaining the problem, describing how the staff's proposal would address the problem, and suggesting possible motions the board members may make to act on the proposal. The motions usually include a delegation to the executive officer to address concerns raised by the board members, to prepare the initial statement of reasons, set the matter for a public hearing, and authority to make non-substantive or technical corrections. There also are options for making modifications if the board members don't agree with the way the regulations currently drafted. So that is always an option when you get text. If you're not feeling comfortable with the policy suggestions or the direction the staff has taken, or you've gotten public comment that you think needs to be addressed and isn't in the text, that would be the time to make those changes, because we don't, in my experience, want to start out with a product that isn't clean from your policy perspective, in your view. So that is always, you'll look in your memos, you'll see the one where you don't have any concerns, but you also see a potential motion where you can make modifications at the meeting. Or even if you don't feel like you need more time, we can always pull the proposal back, make changes, and bring it back to the board. So don't feel, unless the staff are saying there's a fire we have to put out, that you should be pressured into approving the text we bring. We really want to know what you think. We want you to feel comfortable, because you're the one that's going to get the phone call potentially from people about, the things we've done in regulation. So I want you to feel comfortable with that, and just know that that is an option for you when we bring a regulatory proposal to you. Next slide, please. Production phase. So once the board does settle on text and approves it at a board meeting, the staff works with legal counsel to create the rulemaking file, including all the documents that justify the necessity and the authority for taking the action, and everything that constitutes the initial filing, including the documents listed here. In particular, the initial statement of reasons requires the board to explain the necessity of the regulations, and the explanation has to be sufficiently detailed, including providing the source of the board's authority and the rationale for imposing the rule. This is derived typically, though, from the record the board has created during the rulemaking process. All these meetings we have, these discussions we have, is building our record for why the change is necessary. Staff also works with the budget office to research and describe all the economic and fiscal impacts the proposed regulation will have on the public and for government, both local and state. The Department of Finance will also review those impacts, and that is called the Form 399 Economic and Fiscal Impact Statement. Once the documents supporting the proposal are finished, board staff submits the file to the Office of Administrative Law and the Department of Finance if there are fiscal and economic impacts. There aren't always, but when they are, we do have to submit to both control agencies to review and approve. Then the regulation is published in the notice register. So that is the time frame for what we call the initial phase. But before that happens, next slide, we submit your production package through this process. And this is the process for reviewing and approving a package prior to filing with the Office of Administrative Law and submitting to the Department of Finance. So if you're ever wondering, like, gee, why does it take so long? This is your flow chart. I'd like you to look at that and see. It doesn't look bad, but it is. It's pretty intense. And so it begins with our office's review of your regulations. and your executive officer's approval of the package for filing. That takes a very long time, usually 1 to 2 months to prepare and finalize. And so you've got probably at least 2 attorneys, your board counsel and I at a minimum look at your text together for finalization, and the rest of the package is also reviewed potentially by my manager. So we've got 2 attorneys right there. Then it goes to the budget office and it goes through that office's review in light of the Department of Finance regulations, which are pretty extensive. They also make amendments to your documents, and that can take a month right there. Then by law, it has to be submitted for review and approval by the Department of Consumer Affairs Director pursuant to Business and Professions Code Section 313.1. She can also make, changes, hopefully non-substantive, which is why we delegate to the executive officer the authority to make technical cleanup changes. If it's substantive, we'll be bringing it back to you to see whether you want to make changes to your policy in light of the director's concerns, but hopefully she'll approve it. And then it'll go to the Business Consumer Services and Housing Agency, where their general counsel and their agency secretary will need to review it, because according to Department of Finance regulations, you cannot have a regulation approved without the agency above our agency, the cabinet level agency, approving our economic and fiscal impact statement. It's an automatic disapproval if you don't get their signature. They have 30 days to review it. So the director has 30 days, Consumer Services and agency has 30 days. So that's 2 more months right there, potentially. Hopefully it's faster than that, but there's that. And there's another attorney there reviewing it. So we're now at 3 attorneys right there reviewing your package. And we all agree on everything. So no problems there, right? And then hopefully they'll sign it and it doesn't have to come back to you because they have a problem with something that we've written. If there is a fiscal impact, it will be filed both with the Department of Finance and the Office of Administrative Law at the same time. So that, there's concurrent review. They have 30, Department of Finance, that's at the end of the process, sorry. So it goes to finance at the end of the process, but that is another control agency that needs to review the package. We filed the initial package with the Office of Administrative Law. They have 10 days from the date of the initial document filing to review and approve it for filing. If there's problems, we'll have to fix it and bring it back, but usually we can resolve their issues within that 10-day window and it's published. So right there, that's 55 days. After that starts the comment period, it's 55 days. So next slide, please. So we get like I said, once it's reviewed and approved by the Office of Administrative Law and published, that starts the public comment period. It's a 45-day period after the 10 days. So 55 days for that whole initial process to start and end of noticing everything, your text, your initial statement of reasons, your justification for why you're doing it, the notice to interested parties of why you're doing it and the authority to do it, and giving the public the opportunity to comment on all of those documents. Next slide, please. In the official 45-day comment period, board members must consider, after the 45-day comment period closes, board members must consider all comments on the regulation received. So if we get any adverse comments, we'll be bringing it back to you for consideration. The staff and I usually work to prepare proposed responses to comments and our recommendations for how to respond. But again, it's up to you. You don't have to accept our recommendations if you want to change the way we respond to a comment, or you don't agree with accepting or rejecting a comment. That is where you would be doing that consideration at the board meeting. If the board votes to accept the comments and modify text out of concern for whatever reasons that were raised by the public, then a notice of modified text will be issued, either 15-day or 45-day, depending on how substantive the change is and whether it's related to the initial rulemaking. And this process will continue until the board decides that no further changes are needed to the text. The board will then direct staff with regard to policy and will be the final approver of regulatory text. Next slide, please. So we finally make it to the final phase. Yay! Once you've decided on your final language at a meeting, the text is approved by the board, and once again, the board delegates the authority to the executive officer to finalize the package and complete the rulemaking process on behalf of the board. If the motion is to approve the text, the motion will also include delegations to make non-substantive changes, like I said, like typographical errors and technical cleanup to the package, adopt the regulations as approved by the board, and complete the rulemaking process on the board's behalf. After the board's final approval at a notice meeting, staff again would draft all remaining supporting documents necessary to finalize the rulemaking and to explain where the board ended in terms of the text. Like, did we make any changes? Why did we make any changes? Did we accept or reject any comments? Why did we do that? And what is our current position on the policy for this regulation? That's what those documents do. In the final statement of reasons and what they call an updated informative digest, telling people what changed since we started the rulemaking. So again, remember that chart? We have to go through that chart again. Legal counsel reviews the package. It goes to the budget. Well, it would go to the budget office if there were changes, but usually we skip the budget office in the final package. It goes to the director. Again, she could say, don't like where you ended up here. I have concerns. There are exceptions for the director's review when it comes to examinations and qualifications. She doesn't have the authority to review those, only the board. But with everything else, she gets to see the package at the end and approve or disapprove it. If she approves it, and then it would go to agency if there were modifications to the original text. So we'd go through that whole process again, 30 days, 30 days. So 2 months right there, again, just to get the final package filed. Then it gets filed with the Office of Administrative Law. If no control agency has a problem with our filing, Department of Finance or OAL, then it would proceed to become final and approved. The OAL has 30 working days. It's about 45 calendar days to review any rulemaking package and make a decision. If they have any problems with any part of the package and we have to bring it back, you will get it back at a board meeting with an explanation of the issues identified either by the Department of Finance or the Office of Administrative Law, and you'll have an opportunity to address those concerns or maybe go in a different direction. I don't know. It sort of depends on what the concerns are that were raised by the Office of Administrative Law. Next slide, please. So as a board member, we suggest that you read the staff memo and associated documents and come prepared to ask questions, listen to comments, and discuss the proposals brought forward at each meeting. In a preparation for a board meeting, we recommend that you review the staff memos, text, and all underlying data provided to you for any meetings on behalf of the board. Those are the attachments you'll see to the memos. The memos are important as they provide options and reasons for the proposal. Additionally, the supplemental materials may show you why the proposed text is necessary or should, what the new regulations might look like, or what is being changed in the original language or added, really, maybe a whole new proposal. This will give you a high-level review of the matter. While you're reading materials, list any questions you may have so you can come to the meeting prepared and ask staff for clarifications or even approach the executive officer prior to the meeting with your concerns so that we can be prepared to answer them at the board meeting. As a board member, you may ask questions such as, whether other alternatives were considered, or you may look at or ask staff or committees of the board to research how other states or other programs handle similar issues, because these are some of the things I've heard board members ask when we brought regulations forward. But those are just some ideas of things you can do to review these issues. Next slide, please. When reviewing the text, consider the rules you're about to make. We recommend that you review your regulations with the following questions in mind. Items 4 through 9 of the list on the next slide are the main 6 questions that OAL will use to evaluate the standards your proposed regulations are required to meet. As you're reviewing regulations for the board, I recommend that you refer back to these questions and ensure that your regulations meet these standards. So, again, review the memos, the text, and the supporting documentation. Ask yourself if there are any unintended consequences. Is this proposal being brought forward the least restrictive alternative or interpretation that your agency can choose to implement the law, because what that is something we need to think about. Like, is there a better way to make the regulation less burdensome to the regulated community? That is something we have to discuss in the underlying documentation, that we've considered alternatives and that this is the least restrictive one, or we couldn't think of another a less restrictive alternative. We can't really say that if we didn't, right? So it's important that we think about those things and discuss those things at meetings so we can check that box when we're going through the preparation of the justification for the rulemaking. And like I said, the next slide, please. These are the main criteria that the Office of Administrative Law uses to determine whether you have a valid regulation. If you don't meet these criteria, your regulation will be rejected and disapproved. So the first one is, do you need it? You need to have a strong record of why the changes were made, and not just to make the changes, but is this the best way to make them? Why is this the best way to write the text? Do you have the authority to adopt regulations? That is usually not a big issue. I mean, that is something my job is to help vet that. I wouldn't bring you a proposal I didn't think you had authority to do. But, certainly if you have questions, feel free to ask that if you're concerned that it might be outside your scope. Does the proposal make specific or interpret a law under your jurisdiction? So, of course, we want to make sure that we're interpreting a law in your act or the authority that a legislature gave you to do it, to adopt a regulation. We need to make sure we're making clear something that you have the authority to do again. Is it clear? Does it check the box of when anyone picks it up and reads it, can they know what it means? We all have to have the same interpretation. Unlike a law, laws can be vague, like, yeah, do a fee, do an application. The reg has to say exactly what the application contains, the fee that has to be submitted, and what the board, under what circumstances the board will accept it as a completed application. There can't be any hidden requirements where somebody's rejected and they didn't know that they had to submit it in through Breeze or in paper form or to a specific address, or that they had to do something like get fingerprinted before they submitted their licensing app, something like that, or it will be rejected. Well, if you don't tell them and they don't know it, then there's a clarity problem there. And there's also, an authority issue. So also, is your regulation in harmony with, or does it conflict with other California statutes, rules, or federal laws? So, we're currently kind of trying to make our way through that issue with the current scope of practice regulations and how the Respiratory Care Board's regulations affect our scope of practice for our licensed vocational nurses, right? So we couldn't be in a position where we would submit something that was in conflict with their regs or their statutes, unless you have your own authority to do that, and we don't. So there's things like that you have to consider when you're developing a regulation. Yes.
So it might be a question you can't answer, but reading this and listening to what you're saying, I don't quite understand how RCB was able to push through their regulations when it conflicts with is it because ours wasn't clear enough on what we were able to do?
Well, I don't know if can we discuss this as part of what example or no?
I'll just say really briefly, there is a
Statute.
I think there's a statute in the Vocational Nursing Practice Act that says
2960.
that the only people who can control respiratory care services or something like that is the Respiratory Care Board. It's either in our statute,
It's in,
or theirs.
If you look at the meeting materials, we talked about at the Education and Practice Committee, the statute actually gives Respiratory Care Board in your Practice Act the authority to develop regulations that determine what is a respiratory task or service, and that we cannot have that that an LVN can do it consistent with those rules. So they do. So that's my point. You have to look at all the laws that touch on the issue and come up with a proposal that is consistent and not in conflict with those other regulations out there. So that is something you do have to state in your proposal, that you're not in conflict. And if the OAL says, oh, yes, it is, then you're disapproved. Your regs are disapproved. They won't let it go through. So it's important that all of these standards are considered when we're putting a proposal together. I do my best to address all of these standards for you, but it helps to have other eyes looking at it, not just me. You know, I try to do my best to catch all mistakes, but it happens. Duplication, that's another problem we have sometimes with regulations. People think that if it's written somewhere else, people can't find it. So sometimes they'll just repeat things. And so you kind of have to explain, well, is it really necessary if there's already a statute or regulation that covers this subject? And so you have to kind of defend that interpretation. So again, when you're looking at the text, you know, read it first up, just a cold read. Like if you picked it up and read it, would be like, okay, I know what to do, or I know what this means. That's the main reason regulations are disapproved. Is you know, if I hand it to my neighbor and they read it and they're like, yeah, or I hand it to an LVN for scope of practice and they're like, yep, that makes sense. Or they're like, well, what does that mean? Can I do this or that or the other thing? Then we haven't done our job correctly, because again, statutes can be vague. Regulations are the job of a regulation is to make clear what the statute leaves unclear and subject to debate. So if we're debating, right, like we are about the RCB reg, it's because our reg is not clear enough to explain to the public how the RCB regs affect LVN practice. We have not addressed that in reg yet. We need to do that. That kind of thing. Next slide. So finally, if you're, you know, curious, and, you know, I might recommend that the staff put like a link in your materials, like a hyperlink for updates on regulations in the future. If you're curious about like what we have pending, what we've adopted, the board has adopted, this is where all the regulations are housed on the board's website. You can click on that and you can see all the documents we need to support our rulemakings, how labor intensive it is. But as we've seen with the school approval regulations, there's a good payoff for diligent work and hard work on regulations. And, you know, you remain in control of your policy when you put the work in on your regulations. When you don't, then other people make decisions for you. So with that, next slide, any questions I can answer on the rulemaking process?
Sorry. Can we get a copy of that book? Can I buy it somewhere or?
Oh, this you can buy it from the Office of Administrative Law. And we have a contract. They just ship us one every year. So
I'm sorry, really? You really want a copy of that? I'll send you a link, save you the money, but to where the law is for this. But yeah, I mean, it's just a book of laws and regulations. It's not like easy, you know what I mean? It's not like,
well, I mean,
Yeah,
the Office
it's-
of Administrative Law's website also
it's actually really
will
helpful.
kind of give you a full overview and like links to things. So that might be easier to read. But I mean, yeah, we got it from the Office of Administration. This is their book. Yes, I understand. I have them myself.
I'd
Just
like
to-
the name of the book, just because I'd like to
It's called
have it as a
California
reference to go
Rulemaking
through.
Law under the Administrative Procedure Act, but it is basically a reprint of all the California Administrative Procedure Act and all of the rules and statutes that come into play, including building standards laws, because there's a whole different set of rulemaking requirements for building standards that I'm not going to cover because we don't typically, I mean, I don't think this board's ever adopted a building standard. So there are some boards in this department that do regulate like where the sink needs to be in relation to, you know, the dentist's chair and stuff. And that's it. Once you start touching physical things in a building, then that goes in the building standards code and in the building standards commission. There's a whole another complicated process for that. So, but there is some reference to that in here as well, because that is rulemaking.
This is Nelly Nieblas.
Yes.
Is there any way that I can I'm a audio and visual learner, and like I can't do both at the same time. And I'm wondering if I could do or have this PowerPoint presentation, because before we get into the nitty gritty, I just want to have the process clear in my head.
Well, it was in the packet, I thought. Is it in the
Okay.
packet?
I can certainly send it again.
Isn't
Okay.
it online?
Okay, it's online. Okay, I can. I'm sorry, I'm recovering from back
Nikki will
surgery.
send you a separate copy, she said.
Great. Oh,
Miss
I'm
Grady.
recovering from back surgery, so getting back in the groove of things is a little difficult. I
Well,
apologize.
we're glad to have you back and we hope you're doing well.
Thank you.
Yes. Hi. Ms. Carpenter.
Yes, I'm just thinking back and all of the legislation that I've seen over my many years as a lobbyist
Yep.
that said effective date of the legislation. And I'm wondering whether the rulemaking process was taken into consideration in the effective date or if it just started the clock on the process.
Well, we try to get ahead of that when we see legislation coming where we're going to need a reg and they want particularly some policy implemented by, like they put it in the statute sometimes, like we want by July 1, you will have an application on blah, 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 blah. And, January, it takes a year. About a year to get a rulemaking done on the regular. Sometimes we're lucky we can get it done faster, but a year is the time frame from the time of publication till the final rulemaking. We have that long to finish. Otherwise, we have to start over. So we try to get ahead of that, and and we tell the author's office, "Hi, can you not require us to do that by July because it's not possible." We have look. Okay, so the Office of Administrative Law, I just want to tell you, they recently told me that they assign a reviewing attorney, and then there's 7 more attorneys that it goes through before it's approved. So there's 8 attorneys at the Office of Administrative Law that review every one of your rulemaking packages now. When I started, there was 1, then it went to 3, then into 6, now we're at 8. So the amount of review is in the scrutiny is pretty high now for regulations. And it takes a long time. As you see, our process is very complicated. Not all the departments have this kind of complication, but we do. We have a lot of different control agencies that can tell us no. And we have to persuade them that we've done everything according to law and we have authority and all that. That's my job, is to shepherd and advocate for your policy through each level of review with every single agency that touches your package. And it takes a long time to do. And so the legislature just, a lot of the time, they don't have any concept of that. And so it's our job to make sure that they're told, that's nice, July is a great date, but I think the January of the next year is probably more realistic.
Thank
Because
you.
regulations are effective quarterly by law. When I started, they used to be effective upon filing, and all the regulated community had a problem with that. It's, oh, we don't have enough time to get ready, la, la, la. So they changed the law. So only if we show good cause can we get something effective on filing. And usually it's like, we need our fees effective on filing, like we did for our fee proposal, because we were running out of money. And so they're like, okay, we don't want to have to shut the doors. So sure. But everything else is a fight. They go on that quarterly schedule. So even if we finished our rulemaking package in December and it was approved, it wouldn't be effective until April because of the quarterly schedule they follow. All regulations have to be done and completed by the end of November for it to be effective in January. That's the way the current law reads. So if they didn't like rulemaking to take so long, they shouldn't have passed a law that made our effective dates quarterly. Thank you. You want it done, then let's, give us either authority to do emergency regs for, like we did for the school approvals. We got a 2-year window to get our regs through and done. And we needed it. We needed every bit of it because it was complicated. So yeah, I really recommend every time you see a law coming through and you're like, we think there might be a reg needed, make sure that the author knows, hi, by the way, this is the process and it takes a long time. So let's not set us up for failure, please.
Oh, thank you. That's good information.
Yeah.
Is there a standard for when, like we said yesterday, we hadn't looked at our scope of practice for quite a long time. Is there a standard that's like, we should be doing this every 5 years? It should just come up for
Strategic
us?
Plan,
Beg your pardon?
your strategic plan.
Should tell us when.
You should decide about like things that are important to you, like say, I want, you know, this reviewed every 3 years to see if it needs to be updated. Like for the guidelines,
Okay.
I've told Ms. Wood that, you know, waiting 10 years to update your disciplinary guidelines, not a good idea. I mean, that package was well over 150 pages because we waited so long to update them. It was really painful. County Board has a standard every 3 years. They update their guidelines. They don't care if there's been a law change or whatever. They take a fresh look at it because it's the main thing they do, enforcement, right? So when they get their rulemaking through, it's like their updates are a breeze, like pretty easy, easy peasy. You know, people that wait 10, 15, 20 years to update their guidelines, it's so excruciating. I can't even tell you. So find out from your perspective, your board members, what they think is important and set in your strategic plan a goal of, I want these regs re-examined, whether we think we need to change them or not. Well, we'll make that call. The staff will bring it back to you within this window. You'll look at it and say, yeah, I think this needs to be changed, or staff will look at it and say, yeah. So that strategic plan is the best vehicle for maintaining updates, I think.
Okay.
Then you have your rulemaking calendar that you approve every year. If there's something on there, you're like, you know, I really think we need to look at this year. Then you would have an opportunity to amend the rulemaking calendar and say, we're going to do that this year. So those are the two that I'm aware of. There's no law that says we have to, that I'm aware of. There are some boards that got into trouble and were told they had to do it, but you don't want that. I wouldn't recommend inviting the legislature to set your priorities. That's what you should be doing. That's your job. So you're welcome. Anything else?
About the public hearing and comment period, what happened, what has to happen.
Well, so
The WebEx audience was not able to hear the question. If you could repeat it. This is the moderator.
My apologies. I was asking if Council Shields could comment a little bit more, expand a little bit more on the public hearing process, pros and cons of making sure we do that, and what to really expect in that public comment period and what the board would see afterward.
So again, this is a policy call for the board, but the board's standard policy on hearings is that the hearing will only be set if the public requests a hearing during the 45-day comment period, and it has to be made at least 15 days before the comment period closes. So, you know, there was a time with the department where they recommended everybody just have a hearing every time, but then people wouldn't come. So it would just be a waste. So for those items that you think there may be high public interest in, you could say, like, maybe with the scope of practice regulation, you're just going to put a hearing and you're just going to set it up automatically for a hearing right up. That way we get all the comments right there. The board can hear it, or you can have your executive officer take the comments and then bring them back to you in a summary, which is what we have been doing when we had hearings. It's really kind of, I would work with your president to just make those calls unless your manual, I don't remember, says otherwise. But, you know, typically only recommend setting things for a hearing when you know someone's going to ask for one, like fees. They always ask for a hearing on fees because nobody likes a fee increase. If it's a reduction, no problem. But that doesn't happen very often. But for fee increases, we recommend where people, you know, people are probably going to ask for one. They want to have their say in front of the board. But like I said, if it's contentious, then, you know, that might be something you'd consider, but you'd have to set that hearing date up front as part of the notice. And it has to be held at least no sooner than the day after the 45-day comment period closes. So the soonest you could have the hearing would be on the 46th day. And you'd want to have it before well in advance of a board meeting. So staff has time to summarize everything and prepare responses for the board to act on at the following meeting. So it's a little more complicated when you throw the hearing into the mix, but you can get some really good feedback and, you know, clear the air on a lot of issues when you let people speak to something that really matters to them. So it's really a policy call. It's not legally required to have a hearing with every rulemaking.
Can I chime in really quickly?
Yes.
Yeah, so in my experience with regulations, that you can get ahead of a lot of problems or a lot of concerns that people like stakeholders might have with any part of the regulation. You can kind of get ahead of it if you do stakeholder meetings before.
Yes.
So that you can kind of hear in advance what people are going to say, so that when you actually do the public comment period, you don't get thousands of comments. The big ones hopefully have already been addressed. And maybe there is going to be some people who are still unhappy with whatever you wanted to do, but at least you're going to have addressed a lot of it ahead of time.
Yeah.
So it's a lot of front loading, and it does save you a little bit of heartache in the long run.
Well, and
and
I
people
think-
feel heard, and you want them to feel heard.
I think the value also of like having committee or stakeholder meetings is there can be a dialogue. When you have a public hearing, it's just them talking at you. It's not like you can respond to them and have, because then it's a board meeting or a committee meeting, right? So hearings are really just to hear the complaints or comments or input. So the question is like, how much value would you get out of it? Would it be more valuable to have stakeholder comments and meetings and committee meetings like we're having, where we can have the interactive engagement to get to text that everybody feels comfortable with? That's why I think when you have a complicated or contentious issue, even if it's not major or complex, it's advisable to have those meetings before we start the formal rulemaking process. That makes sense? Yes. Ms. Meeblis.
I couldn't agree more. As a person who does stakeholder engagement, having those discussions allows for things that we don't see coming to be brought up. Specifically, you know, for me in my role as a disability policy advocate, there's a lot of patient care issues and training issues that they have that has been brought up when it comes to healthcare policy. And when we have the stakeholder engagements, you know, key things to have are having translators, having an agenda that has our questions that we're wondering what they think about outlined, so that they can answer them for us, so that when we're moving into the actual regulation, we're like, oh, this was answered by this community member's point of view and
Right.
this person's point of view. So it's definitely, I totally resonate with having stakeholder engagement committee hearings, or not committee hearings, but community hearings that would help us kind of streamline our regulations or come up with new ones that will kind of make us innovative in patient care. Thank you.
And I just want to stress that the committees are the workhorse arms of the board. Their
Yeah.
job is to work through the issues, actively engage, to help develop that policy recommendation to the board. So, I mean, it's so much harder to do it at a board meeting
Yep.
and try to come to, you know, and then on the fly draft language. I've done that and it's so stressful. And then sometimes we end up with not a great product. So that's why we are doing the committee, education and practice committee meetings for the scope of practice proposal, as an example. So we can have that engagement, that dialogue, and really be responsive to the concerns raised. Anything else?
No, thank you for being here.
Thank you, and I hope you have a great rest of your meeting.
Thank you. It was excellent. Thank you so much.
Yes, thank you so much, Christy. It was great.
We just moved the agenda item forward. What did you want it for?
Oh, we have to table that anyway.
Okay. At this time, we will move to agenda item 4, Board Policy and Procedures Manual. Ms. Yamaguchi, Executive Officer.
Thank you, Madam Chair. Unfortunately, we are still working on the manual, so we'll have to table this for a future meeting.
Hello, can I chime in really quickly? Based on our reg presentation just now and the questions that some of the board members had about, do we want to have a policy about this, about that? You know what, because it's not done yet, if you guys want to add anything, or because it's still a work in progress, and this is a great time to, since it is on the agenda. I mean, as I was going through it, I may have had a couple of questions about, well, who's the one who decides who puts things on the agenda? I had a couple of questions. So if you have, as board members, want to have some comment about what goes in your manual, because this is where it establishes, this is how, when there's a gray area in the law or you don't really know what to do and there's no regulation, there's no law, there's nothing, but you want to say, as a board, we've decided this is how we're going to handle these situations. I put some language in there about how do you handle the voting when there's abstentions and when does it pass, when does it not pass? So there is language in there about that. So we've addressed that issue that we had last year. But if there's anything else that you want to add, then I can make sure it's included, and Elaine and I can work on that together.
Thank you.
Does this need to be done like today, or can people send it to you? How's the best way?
Yeah,
to take
send your feedback to Elaine. And actually, can I bring up a couple of things since I had notes while Christy was presenting and based on some of the board members' questions? Okay, so these are my thoughts. One of them I already said was who decides what goes on a meeting agenda? Normally it's the board president, but I noticed I don't think that's in your admin manual. So if you want that to be official, you can make that official. Let's see. People had questions about whether the board would do a reg hearing. So if you want to kind of make some decisions or have some ideas about, and this can be something that you guys can noodle on and then email Elaine about, how often do you want to update your regulations? I mean, accountancy used to be my client. I had no idea that they updated their regulations, their disciplinary guidelines every 3 years, probably because they had just done it when I got them as a client. And I only had them for like 2 years. So during that time, I didn't do any full regs with them. But do you want to put a policy in place as to, hey, at least let's revisit them? Maybe we won't actually update the regulations, but let's at least revisit them. These are just concepts I'm putting out there willy-nilly. I mean, part of them are thought out.
Let's get a question. So when you say like disciplinary guidelines, but there's also scope of practice, should we have in our 5-year plan, should we be saying we want to, because healthcare is changing so rapidly, we really should be looking at our scope of practice probably every 3 to 5 years.
That can definitely go in your strategic plan, but it can also go in your board policy manual.
So would that be something to discuss at a board meeting?
Absolutely.
Determine how the board members feel about that?
Yeah, absolutely. Yeah, so right now, let's just put it out there as a concept.
Okay.
Because the agenda item is broad, but not so broad that we can really go into that level of detail. But I do encourage all the board members to think of things that you're like, you know what, I thought about this a few meetings ago and but there was nothing to direct us on how we wanted to do it as a board. So if there's anything like that that you think, hey, I want to put this in writing, I want to have this as a reference to future board members later on, then this would be a great time to kind of noodle on it and then send Elaine your ideas. And then at a future board meeting, the board can talk about it. And then I can put it in your manual.
I'm wondering if, for me, one of the things that I'm experiencing personally and have experienced in the past is some really good patient care and some really bad patient care. And I am wondering in the education committee, if we can discuss maybe training on how to deal with somebody, how to deal with people with disabilities and kind of codify a training so that every person who goes through the LVN PT certification process has at least some awareness of different disabilities and how they manifest in people. Just to share something that happened to me literally a week ago. My surgeon looked at me and said, "You speak and you have cerebral palsy?"
Nice.
I was shocked. Needless to say, I went for a second opinion, and he also was shocked that I could actually move. He had no idea. I asked him if he read my file, and he said yes, but he had no idea what cerebral palsy was by the way he treated me. And I'm pretty sure I'm not the first patient with a disability he's ever encountered. I'm just trying to avoid that kind of shock experience or lack of awareness for our nurses and our PT professional, psychiatric technicians professionals. So, I mean, I've experienced this before. I can't believe I experienced it again, and I'm expressing kind of a need for a training module to be in part of the training that a person requires to get as a result of being an LVN or PT.
Actually, would you mind if I comment on that? Actually, the curriculum in our regs does require all the programs to have certain units on basically a diverse patient care. But what you're looking at, I think, is one, a little bit more intensive, but two, I wonder if this is something that, I mean, obviously this is something we'll need to discuss at a deeper level with like the committee. But are we thinking about looking at the sort of standardized curriculum, or are we looking at maybe continuing education programs, or both?
I'd like it to be part of the standardized curriculum so that it's just part of at least the essentials. And then if they want to go into deeper understanding of, for example, what autism exhibits like, or what cerebral palsy looks like, what kind of, and something as basic as accommodations that will help a person in a wheelchair versus a person in crutches. Yeah.
Okay,
those kinds of
sorry to interrupt. I think this is a great topic, and I think it's a great topic for a future meeting agenda. And it can also be something at the next education practice committee that you guys can think about adding. So yeah, I just don't want to let you guys get too far off track to avoid any
but I
issues.
just was wondering where exactly I can speak about that, and that's the perfect segue. Thank you.
Absolutely. Perfect. Do I need to add? Gloria has a comment.
Just to add a comment to the, I don't know what the standardized training or licensing process is now as far as the curriculum for school for LVN programs. But when I attended, which was many, many years ago, we did actually go through, I believe it was maybe a month in a cerebral palsy foundation facility where they had inpatient, patient, and outpatient. And at that time, we did care for cerebral palsy patients, and there is a spectrum. And now with autism, there is also a broad spectrum with autistic patients, because I've dealt with autistic patients where they have very limited cognitive ability to express themselves. And then as the years go by, because I served some patients for almost the span of their entire life, go from being nonverbal to actually communicating on their own at the age of like 16 or 17 years old. So there are, it's just so broad, and it's very individualized with cerebral palsy and with autism. So it's
I'm sorry, I have to interrupt.
Sorry.
This is a great discussion. Let's save it for another meeting. Thank you.
But I just wanted to say that it was included.
Absolutely,
it's a
and
super good idea.
yeah, and it's a shame that we can't discuss it now, but
Understandable.
But in all likelihood, though, that's a clinical facility issue, because it sounds to me like, all the programs are given some degree of academic freedom. So some programs are a little bit better
Mhm.
about some things than others, but that is definitely something we would want to discuss. Especially that the need for that is growing so fast.
Yes.
Mhm.
it is.
Ms. Butu, should I ask for public comment?
Yeah, sure.
Yeah, let's go ahead and open it up. Are there any other comments from the board? All right, seeing none, is there any public comment in the room? Seeing none, can we ask if there's any public comment online?
Certainly, this is the moderator. If anyone would like to make a comment, you may look for the hand icon, typically at the bottom of your WebEx screen, or if you're on a mobile device, that might be behind the 3-dot other options. Each speaker will have 3 minutes with a 30-second warning. Are there any comments on this issue? I do not see any raised hands. I'll turn the meeting back to you.
Thank you so much.
You're welcome.
I believe we're at agenda item 5, recess. And this open session stands adjourned at 11:06. Is that correct? Wait. Go ahead.
Don't adjourn. Recess is perfect.
Just recess.
Recess, because adjourn
about
means we're
recess?
ending and recess means we're taking a little break.
Okay, so
Or
we will
breaking
take,
until tomorrow.
we'll just take a break.
We're recessing until tomorrow
Mhm.
morning.
So we are recessing until tomorrow morning at 9 a.m. All right. Same time, same place.
Thank you, everyone. Thank you. Fine-ish.
Wow. 9. Yeah.